Hi, everyone. Harry here to talk about what is shaping up to be an unbelievably challenging, controversial, polarized decision for the U.S. Supreme Court in the Colorado case implicating Section 3 of the 14th Amendment. This is the disqualification issue. The court has set for very quick resolution, and they're going to be hearing it February 8th. Well, everybody has taken notice and everybody is into the pool. So just so far, all we have a few days ago, Trump submitted his petition on the merits. Still have to hear from respondents on the merits, and then a reply brief that's just a few days before the February 8th oral argument. But we have some 40, count them 40 amicus briefs, and they are growing. I clerked there, and there would be the occasional case, often involving hugely consequential boring business issues, but where you'd have these stacks of briefs that you have to go through, and some clerk is going to have to go through all of these, many clerks for every chambers. And moreover, you just have such a who's who of the legal establishment on both sides of things, and it stands to reason, because the court is so at sea. It's such a case of first principles, and the implications are huge for the court's role and the nation, that it stands to reason that a few of these amicus briefs are going to get purchased and be very influential. And they're going to get kind of a buzz and be, in addition to the briefs on the merits, be really considered. So I won't go through all 40, but I've done a quick blitz of them, and I wanted to target 5 or 6 that are from important, prominent people that would make the court or a clerk sit up and take notice and tell you their basic arguments. 1, so you know them, but 2, to get an overall sense of, man, we are all over the map in kind of every way, from whether they should consider it, whether they should tackle the merits. Some say you cannot tackle the merits. Some say you must tackle the merits. And then if it goes to the merits, what should they fasten on to? All of this kind of is congruent with what I've written about, that the court is really has a handful of options, none of them very good. Okay, so just so you have it in the back of your mind, there won't be a quiz, but it'll be good to have sort of heard of this, because any one of these could emerge and be in the middle of the case as the court actually hears it. So 2 brothers, the Amars, who teach at different schools and are sort of idiosyncratic and known for their offbeat or just distinctive views, have come in with a brief all about the so-called first insurrection. And their thesis is that the insurrection that drove the Section 3, which, as you know, says if you've sworn an oath to the U.S. and you then engage in insurrection, you can't serve thereafter. They point out, as a historical matter, there were 2 insurrections, one sort of early in the 1860s period, and then the full-fledged Civil War. And so their argument, an interesting historical argument, is where we are today is a lot like the first insurrection. So for people who want to say an insurrection is only, the guns drawn and thousands of people in the uniforms of the Confederacy and the like, no, that's not right. This, in fact, is just like the first one. They say something else, which I think is true, and I've said as much, although I don't think it's going to be the final word for the court. But there's no constitutional requirement for consistency. The Constitution itself is not offended if Colorado doesn't have him on the ballot and Wyoming does. In fact, that's more consistent, I think, with the scheme that both the founders and keeping up to the 14th Amendment drafters would have had in mind. On the other hand, as I've said, it's just not culturally, politically what our system is, because our system, notwithstanding its distorting feature of the Electoral College, really is a national election. Finally, they say that there's a possibility that Congress could actually supplant the court's decision if it sort of bottom lines, and so this is styled, by the way, in support of neither party. There are some amicus briefs for petitioner, some for respondent, some want to make some good points to the court. So that's the Amars. And they're prominent, if kind of offbeat, professors. Now, Ned Foley and Ben Ginsburg, this is one that is eye-catching because it's people who were on either side of the Bush v. Gore debacle. That's the closest thing to what we've had before. And their first point to the court, this is way worse than 2000, and the nation is absolutely on the precipice and polarized, and disaster could strike if the court messes this up. And these are the people who brought you the disaster of 2000. So first, their first argument is you do not need Congress to act. That's a whole theme. Must Congress actually do implementing legislation that says, here's what an insurrection is, or even here, Donald Trump did thus and so. No, you don't have to do that. That's point one, so don't wait. But second, they say, and this is the point that their brief stands for, you must resolve on the merits. If you don't resolve on the merits, we're like going over Niagara Falls in a barrel. It's worse than 2000. And by the way, if you don't and you say Congress has to do it, well, guess what? It's a near certainty if Trump wins that Congress, at least many members, will move to disqualify him or vote for it if the court says they have the authority. And you can imagine a situation where the Dems have taken both houses of Congress and they use the authority the court proclaims for them, and they bounce Trump, and it's even more political, and absolute bedlam ensues, and democracy breaks on the shoals. And these alarmist tones are really throughout the different briefs, and they go on different sides of things. I don't remember a case where the court has been told as clearly, the sky is falling and you got to catch it one way or another. Okay, Foley, Ginsburg say you got to decide it and on the merits. So it's in support of neither party. I think if the court said, it doesn't apply because he's an officer, the president is an officer. Pretty lousy argument, but as I've written, might be the least bad of all worlds. At least that would be a decision on the merits. That's their main point. You can't wait for congressional action. The Constitution doesn't require congressional action, and it's up to you, court, to step up. Okay. A number of professors and legal scholars, not hugely prominent, but enough maybe to catch the attention of the court. They take on what the court did in the gerrymandering cases and might want to do here, where the court said in gerrymandering, we are out of this because there are no judicially manageable standards for us to apply what a partisan, unduly partisan gerrymander is. Here, say the professors, and they're right, it's not like that. There are judicially manageable standards. You can figure out what an insurrection is. You can figure out what engaged in is. And by the way, you have the authority to do it. They suggest Congress may have authority, but doesn't have exclusive authority. And also, they analogize it. This is going to figure over the case a lot too. If this is so hard, we know states all the time can and do decide should someone be on the ballot because they're not the right age or they're not the right nationality? And, that happens. And obviously, as a matter of magnitude, a presidential election is different, but as a matter of process and legal sort of division of responsibilities, they say no. And then finally, again, as the Foley and Ginsburg brief, only the court can provide a final definitive answer. So you can't, another one for not punting and having some definitive answer. Now, this has been widely reported, 177 members of Congress. I think they are all Republican, but in any event, all the big Republicans like Cruz and Scalise and McConnell and Cornyn and Cotton, all the crew that basically voted to acquit him in what remains, to my mind, the biggest sort of missed opportunity in this whole long nightmare, which is McConnell standing up there basically saying, we know he's guilty, but we're not going to vote to convict him. And that really would have, put things to the side. All right. They now are saying, however, hey, we're Congress. Only we can do this. You need federal implementing legislation. And you can't do it on your own court. And that's also, you have to be very careful because engaging in insurrection, the Colorado Supreme Court was too loosey-goosey about it and can too easily bleed into just partisan grievances rather than the kind of big civil war example that the framers had in mind. Of course, now see the Amar's brief where they say there's that first insurrection, it's smaller, and it's not what they have in mind. But basically, they're saying we've got to do this. And of course, that runs like a buzzsaw right into what Foley and Ginsburg say, which is if that's what you say, you're inviting absolute democracy-ending bedlam once Congress is elected. Okay, but they're all that's all the Republican folks, and certainly the court will take notice. All right. Another entry in the hard right sort of crowd is former AGs Mukasey and Barr and a couple very conservative legal scholars, Stephen Calabresi and Gary Lawson. They take this argument that, I've suggested it's really doesn't hold much water, but it might be the least bad they have, which is the president is not an officer under the text of Section 3. And that is a way out in a sense that does maybe the least harm. It's sort of like, deciding this sui generis. They also say, though, that you need some enabling legislation. You can't do it on your own. Congress has to do it. Big problem there is we know Congress doesn't have to have enabling legislation to make Section 1, the part of the 14th Amendment everyone was aware of, whereas Section 3 vaulted from obscurity from January 6th. But that Section 1 is the powerhouse provision, maybe of the whole Constitution today, equal protection, due process, and you don't need enabling legislation. Why would you for Section 3? But anyway, they say you do. It's probably a pragmatic piece that's telling them with a bit of a wink and a nod, here's your least damaging way out. And then finally, the NAACP, in support of respondents, that is the people who won in Colorado below, and they're straight down the path of, you can do this, and this being disqualify him, and you should do this. First, it's self-executing. That's the sort of that's the opposite of the position that the AGs just took, as I described. AGs say you need Congress to do something to execute it, and NAACP and others say no, you don't. It self-executes, meaning you don't need a separate criminal trial. You don't need congressional enabling legislation. This is something a court can do, and in fact is given over to courts to do. Presidents are included. They go through. I've said all the arguments that the court could consider to impose a uniform solution that keeps them on the ballot. All of them have flaws, and they go through the flaws. Presidents are included. You can't try to isolate them. It's not officers. No, it's not non-justiciable. You have judicially manageable standards. And you know what? We are really on the precipice. This is what this was all about. And there's a whole, especially we have some of these being partisan interests and some of them being just abstract interests. There's a lot of interest here of everyday voters of color, and who basically say, you've got to disqualify him on the merits. So, and this is 5 out of 40. Some of the more prominent ones, of course, but can you see how they totally run the gamut from, don't even get involved in this to get involved all the way, and everyone is saying, and if you don't, disaster awaits. So I've never seen a case quite like this for the court that combines such open-ended, unsettled law and such huge political moment. It's clearly going to be one for the ages, and then you superimpose on this the divisions within the court, the propensity of some justices to be receptive to institutional concerns of the court and the country versus others who are just like bomb throwers, so Roberts and company, and Roberts, and whom could he bring along? Maybe Kagan, Kavanaugh, others for like, we need to speak together here. And, Alito and Thomas saying, screw that. This has everything, and it's just like, you've thrown up a deck of 52 cards, and which one is gonna, fall face up and in the middle. It's really, really vexing, open-ended. You could say very interesting for the court, but then I think you think immediately of the old curse, may you live your life in interesting times. Man, is this going to be an interesting time for the Supreme Court. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.